You're all set?
Yeah, as long as we take a break before we start at 6.
Take a break before the
Okay.
6 o'clock.
Or 6.
So between the two, all right, let's call the meeting to order.
Shouldn't be that long.
I'd like to call to order the City Council work session on Monday, January 9th, 2017. There'll be a regular meeting following at 6 p.m. So as I look, we're all present. We have one item on the agenda tonight. I'd like you to remind council to refrain from asking questions until the staff presentations are complete. Well, thank you. Council will receive an update of the judicial branch activity for the Goodyear Municipal Court for FY 14-15 and FY 15-16, as well as the future court initiatives. Honorable Michael Simmons, presiding judge, Crystal McCrary, court administrator, are here to present. Hello.
Good evening.
Thank you. Good evening.
How is everyone this evening?
We're doing well, I think.
Ms. Mayor, Ms. Vice Mayor, I always knew that at some point you would become associated with the word vice. I just wasn't sure when.
I'm not sure either.
Right. It's an attorney thing.
No.
Okay.
Are you putting that in the minutes?
Do we have
Anyway,
this?
how's everyone this evening?
I'm good.
Good? Okay. On behalf of our city court, myself and my family, I want to take this opportunity to wish everyone a very happy, healthy, and successful New Year. Most of you are already very well acquainted with our court administrator, Ms. Crystal McCrary, and she'll be very capably assisting me in our presentation this evening. Now, we are going to have some slides. You'll find the slides very basic. These are not as sophisticated as some of the ones you see from some of your other presenters. And I'm hoping that you all received what I call the report. It's actually entitled Executive Summary. Everybody get one? Okay. I'm going to go a little bit out of order because I want to cover what I believe to be the more important aspects of this first. So if you don't mind, if you are going to follow along in the executive summary, I'll be beginning the bottom half of page 4, where it says operating highlights. Everybody that wants to? Okay, good. Now, probably the most important thing are these case filing statistics. And what we've done is we've compiled a comparison comparing fiscal year 15 to the most current fiscal year 16. The first comparison that I think jumps out is that the actual total caseload is down from a little bit over 8,200 cases to close to 7,800 cases. In other words, the caseload was actually down 454 cases, which is a 5.5% decrease in caseload. However, that really is not the totality of the analysis. The analysis gets a little bit more interesting than that, specifically having to do with the mix of cases that are involved. And if you look a little more closely, what you're going to find is that the number of civil traffic cases is actually down 600, while the number of misdemeanor non-traffic, in other words, criminal non-traffic, are up 26%. That's a pretty big and significant jump to a system such as we have, to a municipal court system. Okay, why is it significant? Well, the misdemeanor non-traffic cases are much more time-consuming for both the prosecutor's office, am I right, and the court. As an example, the prosecutor's office is not involved at all in a civil traffic case. This morning, we had 120 people come in for civil traffic arraignments. So we're talking about, speeding tickets, running a red light, running a stop sign. I personally only need to speak with each of those people about 30 seconds, and the prosecutor's office not at all. But once we go to criminal non-traffic, this is where our resources, the joint resources of the court and the prosecutors, come into play. Now, just to be clear, what we mean when we say misdemeanor non-traffic, we're talking about, unfortunately, domestic violence cases. In addition to domestic violence cases, possession of drug paraphernalia, shoplifting, theft, trespassing, all right? In other words, all of the more criminal-oriented cases that we deal with. So, again, although the total caseload is down by 454 cases, unfortunately, the misdemeanor criminal is up 26%.
I can wait.
I think you should wait. Just can you write it down and let them get through this, and then we'll.
I'll answer it, but I think they want
no,
you to
no,
wait.
we're going to follow the rules
Okay,
here.
no, we will, especially with the judge here.
Yeah.
Okay, Bill, let's follow the rules. And we have the
Yes,
chief
sir.
here. We have the chief here. We don't want to book you. All right.
Oh, please do.
Please do. All right.
No one will bail me out.
Now, as city government, you may be interested in why this is so, why this occurs from one year to another. Unfortunately, I can't offer you a hard and fast explanation for that. It may just be a fluke, a bubble. Something happened in a particular fiscal year that doesn't normally occur. It may actually be the case that, unfortunately, these criminal non-traffic cases are up as our city grows, gets larger. And it may be the case that there is some sort of difference in law enforcement policy. I don't know this, but perhaps our PD is following a policy of pursuing these heavier criminal cases as opposed to the traffic ticket type. I don't know that, but that's a possible explanation. So although I can't explain it, these are some possible explanations. Now, the other thing that's up, and it doesn't look significant, but it is, are the last item, protective orders. Now, again, what we're referring to here is orders of protection and injunctions prohibiting harassment. And you'll see that in the course of a fiscal year, we did 39 more of them. That's over 3 a month, almost 1 a week. And that represents an increase in 18%. All right? Now, once again, is that just a one-year bubble? We're not likely to see that repeated in future years. Or does that say something about how people get along with each other these days, particularly some of our neighbor situations that we have here in Goodyear? I don't know. But that is up. And what happens with these is the actual issuance, the ex parte issuance of the protective order, for example, we've already done 2 of these today, doesn't really take much of the staff's time or my time. When a person comes in and files an ex parte petition for a protective order of some kind, either an order protection or an injunction prohibiting harassment, they're alone when they fill out the petition presenting the facts necessary for the order. And then I will take the bench, if I'm not already on the bench, and I will swear them in, and I will discuss it with them for a period of time, making sure that, in my opinion, there are sufficient facts to support the issuance of the order or the injunction. That does not take a lot of time, especially with the number of them I've done. It comes relatively easily. However, What we're also seeing an uptick in, and this is not represented in the statistics, unfortunately, is the number of those that go on to a hearing. In other words, again, the procedure is the defendant, the person that the order or injunction is against, will come into court and say, I want to challenge this, I want my hearing. And we're seeing an uptick in this also, and this is where it gets time-consuming and resource-consuming for the court. This past fiscal year, I'll give you two examples of this. We had examples where both myself and one of our better pro tem judges, Judge Craig Ring, who's also the part-time presiding judge of Litchfield Park, we had issued orders protecting ladies who I believe were residents of Pebble Creek, having to do with a gentleman that they felt was making unwanted advances. And it was interesting that they were both married, and yet the husbands didn't seem to seek any type of, didn't look to handle it personally. They actually came into court to take care of this. I find that very interesting. I think in the days when I was a kid, I think if something like that had happened, my father would have just found his own way to take care of it, if you will, without
You would have seen him anyway.
Yeah, without involving the local courthouse. Then I would have seen the husband, right?
Yeah.
Right. Then we'd have the husband on an assault and disorderly conduct, right? But anyway, I'm just saying. But these involved hearings that went on for in excess of a half a day, almost the better part of a whole day, where both parties were fairly affluent people that were both represented by attorneys, and in both cases, I knew, and I believe Judge Ring knew, that whatever we did would be appealed, and sure enough, whatever we did was appealed. But in other words, it's not just a case of the number of the petitions of these protective orders going up. When you see the numbers of hearings requested also going up, then that does tend to consume resources. I'd like to move on to page 5. In page 5, we present to you our clearance rate. And the clearance rate numbers are interesting. Joe, you'll probably like these numbers. The percentage of the clearance rate is up, while the actual number of cleared cases is down. Okay, the percentage is up, but the number of cases is down. This is largely due to the fact of the lesser total caseload. This is calculated on total caseload. So when the total caseload goes down, the number that you're using to calculate the percentage has gone down, and so the percentage cleared has gone up. Now, this is an important statistic because it's showing not only the rate at which we're clearing current cases, but it's also reflecting the rate at which we're clearing older cases. All right? So let's take an example. If we have a case that's filed in June, which is the end of our fiscal year, it's not likely to be cleared or terminated by July, so it's going to show in both fiscal years. But under the guidelines that we as judges are supposed to follow, we're supposed to clear these cases within a period of not to exceed 6 months, particularly what are considered the higher priority cases, DUIs, domestic violence, these types of things. So what you see is reflecting that. You're looking at cases filed in one fiscal year that are concluded the next fiscal year, but are done within the time frame that we as judges are supposed to be clearing them. The terminated case rate also can be seen usually as somewhat reflective of the revenue generated by the court. All right? So the clearance rate is important. Now, our next standard is the time standard compliance. And as the paragraph points out, we're under certain requirements that are placed on us by the Supreme Court of the State of Arizona, the Administrative Office of the Supreme Court, and Superior Court. There is an administrative order that goes back about 2.5 years that addresses this. And I want to report that we're in full compliance with this time standard requirement. And not only are we in full compliance with the Supreme Court time standard requirement, we also report these in our city stat reporting process. That is not required by the Supreme Court. Bluntly, they don't care if we report that to you or not, but I want to do it, and we do it. Okay? All right. The next item is an item of, I'll admit it, some pride to me as your presiding judge. This has to do with operational reviews. The Administrative Office of the Supreme Court has one or more teams of people that they're able to send out to the various courts to examine pretty much with a fine-tooth comb every detail of their operation to determine compliance. The very first one of these that I ever experienced was when I first came on here 18 years ago. And I requested it. And our court administrator at the time, Jeff, he agreed with that because he felt that that would give us a baseline, a guideline, almost an instruction sheet as to how to improve the court and how to bring the court up to requirements. So we requested that, and they did come out here, and they did do an operational review. And as I recall it, if anything, this number is low. They found 56 deficiencies. So there was one day there when Jeff Fine and I were looking at this operational review from the Administrative Office of the court that says your court has 56 deficiencies. So, of course, we had to get busy and we had to do whatever we could to correct it. In those days, we were still at the building over on Van Buren, the little brick building. There were some things that had to do with space requirements that we couldn't correct. It couldn't be done, which is one of the reasons why in those days we ended up converting the old Checker Auto Parts building on Litchfield Road. But anyway, now what happens is the Administrative Office of the court ideally tries to do an operational review on each court every 7 years. The reason I say ideally is they don't have the staff to do that. They just don't. Each of these reviews could take a week or more depending on the size of the court, and they're sending in a team of 2 or 3 people at a time to do these things. So what happens is they tend to take a look at each court based on compliance with all the requirements. If a court appears to them to be enough in compliance that they're not a problem court, there are no major issues, then they can elect to skip the operational review. So, again, it's with some pride that I say the Administrative Office of the Supreme Court has decided that we're one of the courts that will not require our 7-year operational review, and they are skipping our operational review, and they have not announced when the next operational review may come, if ever. My guess is, this is only a guess, that whoever may be the next presiding judge may want to do what I did back in the day and request his or her own operational review, giving that judge, that new judge, the same type of base or guideline that Jeff Fine and I had going forward. But anyway, no operational reviews from the Administrative Office of the Supreme Court in the foreseeable future. Now, I know the next portion of this has to do with looking ahead. I'm going to skip that just for a moment. In fact, Crystal is going to present that for us because at her age, her vision is much better than mine. Right? Okay. I'm just saying.
I'll agree with you.
Thank you, Ms. Mayor. I appreciate that. It's very nice to have the moral support. All right. Anyway, I want to go back to page 1. We're going back to square one. Now, I want to discuss for a few minutes, because I'm also very proud of this, our training, development, and succession program. This, unfortunately, has had to come into play within the last 10 months or a year or so, and I believe has done so successfully. The first thing has to do with the mental health court. Through the years, very gradually through the years, the city court systems have come to recognize that most city courts, particularly as they grow, cannot continue to be a one-stop court dealing with all types of defendants with all types of problems. And in our court, again, I don't have a hard and fast statistic on you for this, we are increasingly, unfortunately, dealing with people that have alcohol abuse problems, drug abuse problems, mental health problems of other sources. Some have problems, what we call codependent abuse problems, where it's either a mental health problem and a substance abuse problem, or two types of substance abuse problems. We're starting to see this in greater numbers. So the court cannot ignore this type of training for mental health court. Now, it's long been the practice in the municipal courts for decades that if a prosecutor or a defense attorney is speaking with a particular defendant and they suspect a mental health issue, then they'll go to the judge and they'll request that the defendant be referred for what we call a Rule 11 pre-screen, all right? Which basically is a screening that the defendant goes through to determine if that person has the capability, basically, I'll speak generally, of proceeding with their case, all right? Usually, in fact, maybe too usually, that is found to be true. Once in a while, they find that somebody needs to be referred for what we refer to as a full Rule 11, in which case they go to a court-appointed psychologist or psychologist, and a full mental or psychological workup is done. And again, it's done with the purpose of determining how that case is going to proceed into the future. I had the pleasure this past year, I think it was in the summer, of attending a special course at the National Judicial College in Reno, Nevada, where the topic was co-occurring disorders. In other words, where you have not just one psychological or substance disorder, but more than one co-occurring at a time. And this is taking place also. Now, some courts have already begun to have special sessions. For example, just a DUI court, special session of court one morning, one afternoon, just for DUI. Special domestic violence court, one morning, one afternoon, just domestic violence. Other types of cases, maybe drug paraphernalia or drug possession cases. One morning, one afternoon, just that. We haven't gone there yet. But again, I think it's something that's inevitable. As our city continues to grow and prosper, it's inevitable we're going to get there. And if it's not done while I'm the presiding judge, it's going to have to be done by whoever is the next presiding judge. So this is something that through all this training becomes obvious. It becomes clear. This is the future. Now, in terms of our staff, again, I'm very pleased to announce that we do have in Arizona, an Arizona Court Supervisor Program. According to the numbers in our document, we have 2 graduates and 3 attendees. I happen to think there's actually 3 graduates now. Do we have 3 graduates, including you? Almost 3. All right.
2.5.
Almost 3. 2.5 graduates.
2 3/4.
And the rest are attendees. In the next level of continuing education programs for staff, there's the Arizona Court Manager Program, what's sometimes called the Certified Court Manager Program. And once again, we have a graduate, and we have one currently attending. And for the highest, if you will, level of staff education, we have the Arizona Court Executive, or what's known as the Court Executive model, and we currently have 1 attendee. Okay. Now, I want to stress something about this to all of you, because this, I think, is significant. I, as the presiding judge, am not in a position to take a member of the court staff aside and say to them, you must attend this continuing education program. I cannot do that. I have, according to all the law cases, I have pretty good authority over my staff. But unless I'm mistaken, Mr. Massey wants to tell me I'm mistaken, I don't have the authority to single somebody out and basically say to them, you must attend this continuing education class. Would you concur with that? All right, thank you. I appreciate the concurrence. I would say that was
Would you
somewhat
say yes for the public,
equivocal,
please?
wouldn't you?
Yes, I would.
Yes. Well done, like an attorney. That's okay.
Hire me, we can talk about it.
So what? I might. How much do you make? No. Anyway, my point is, everybody who has graduated from these programs or is currently attending, they are doing so voluntarily of their own free will and volition. Just so everybody knows. All right. Now, late last year, we had the unfortunate necessity of having to hire a new court administrator and a new court supervisor. Now, I got together with Mr. Dahlke and with Lyman and with Ms. Farmer, and we all agreed, I believe there was a 4-way concurrence, that the court administrator position was of such significant importance that we needed to do what to us is a major recruitment for the position. So we did a major recruitment for the position, and among our committee or our panel that conducted interviews, what we had was, what was there, 50-some applications? Yeah, there were like 50-some applications. The first thing that happened before anybody in the court, even me, even touched them, our Human Resources Department went through them and screened them all for meeting basic requirements. And that was very effective. And I want to take this opportunity to thank the Human Resources Department for their time and effort in doing that. That was very nice of them. So anyway, we did a major recruitment, and a number of people were interviewed through the course of an entire day. We had a panel of interviewees that did not include me. However, it did include some court administrators from other city courts, other municipal courts, including other West Valley courts, people that I was aware of had some experience, were court administrators of significant experience. And as a result of that, Crystal somehow got selected to be the court administrator. So it goes to show you maybe some of this succession planning works. Right? However, in promoting Crystal, that then created an opening, if you will, in the court supervisor position. And once again, we did a recruitment because it's an important position. And once again, the Human Resources Department was of great help, including, I believe, in particular, Ms. Sherry Farmer. And the applicants were narrowed down, and an interview process was held. I was not part of the interview process. And as the result of that process, one of our Clerk 3s, Priscilla Pena, who has completed 2 of these courses, was promoted into the court supervisor position. So I believe that the succession planning we do within our court structure has worked very well for us and has helped us through some rocky times. I'll put it that way. It's helped us through some rocky times. And it would be my intention to continue with this type of succession planning and training and development. Now, with regard to interpreters, as you're all well aware, we have our own full-time court interpreter. She kind of does double and triple duty in terms of other things also, but we have our own court interpreter. But I point out at the top of page 2 the administrative orders that affect the interpreters, Order 2015-98, 2016-02, etc. Our current court interpreter is currently going through what is now another advanced program. In other words, continuing education in interpretation. Even though she was born and raised in Mexico and grew up her whole life in the United States and has a college degree in interpretation. So I wanted to point that out. In terms of my own personal education, I believe many of you are aware, I take particular pride in my own personal education. When the National Judicial College has a program that applies to our court that I believe could be of benefit to our court, I try to make time to go up there for that. This past July, just 6 months ago, I was awarded their Certification in Judicial Development Special Court Trial Skills. So I'm probably well enough educated to continue for a little while. Okay. Again, as I know you're well aware from prior years, we involve ourselves in community outreach and community partnerships. The 2 biggest of these, the ones that I'm most proud of, is our partnership with the Veteran Court Program and our partnership with the Homeless Court Program. These are the 2 that I'm most proud of. In fact, just today, Crystal brought me a request asking me to serve as a judge for one of the homeless court programs. Unfortunately, this particular schedule has them all on a Tuesday afternoon, which is our busiest criminal afternoon. We have our biggest criminal docket Tuesday mornings, Tuesday afternoons. So I was not able to accept one of those invitations, but when they start to schedule them on a day other than a Tuesday, that's when I will do that. Either that, or I suppose I could volunteer for it and bring in a pro tem judge. The only reason I hesitate to do that is because it would then be costing us money to pay a pro tem judge so I can go volunteer. I don't think I want to do that. I would rather do it on a day when I don't have a docket and don't have the requirement of a pro tem, the expense of a pro tem judge. All right. At the bottom of page 2, I describe a little bit the access and fairness plan. Once again, it's a language access plan. This is mandated by the Administrative Office of the Supreme Court of Arizona. Now, at the very bottom are the statistics on defendants that do not communicate in English language. It may be.
Judge Simonson, I'm going to have to interrupt you. I
Thank you.
apologize, but we have to start our next meeting at 6 o'clock because it's a public hearing.
Okay.
So maybe you were not aware of that. So we have about 3 minutes to move ourselves up to the dais and begin our meeting.
Okay. Can I take
Okay.
questions?
Any,
Mine can wait. I can do it.
you can wait.
You can ask
we
me in the hall.
We can certainly come back after this.
I'll just ask him when we do his review, his judicial review.
So,
I've got him.
That's correct. We'll be meeting again in 2 weeks.
right. So could we
So-
ask those questions and you
I'll
could
take
give
all
the
the
answers?
questions you want
and
at
so,
that meeting.
okay.
I think that's a very good idea that
All right.
Councilmember Campbell had.
We appreciate all the information you've given us and the presentation, but we're going to call this meeting to an end and start going to the dais, everybody to begin. Thank you very much.
Thank you
This
very
meeting's
much.
adjourned.